in place, and counsel I can see, so I will ask my clerk to call the case.
In the Court of Appeal, Civil Division, before the Master of the Rolls, Lord Justice Henderson and Lord Justice Nugee, in the matter of Alta Trading UK Limited, formerly known as Arcadia Petroleum Limited and others, versus Peter Miles Bosworth and others, case number A4 2020-1890, Wednesday the 5th of May 2020.
Thank you. Can I just make a few introductory remarks? This is a remote hearing, obviously, but that doesn't make it any less formal and any less a court hearing, so I would be grateful if all the parties and their representatives would abide by the normal rules of appearing in court. If everybody can keep their microphones muted when they're not speaking, that will ensure reasonable quality. We have a day and a half fixed for this hearing, which seems a lot to the court, but I'm assuming that counsel have divided the time between them, and there is no question of going on beyond the day and a half, and the court would be absolutely delighted if the case were capable of disposal within a shorter period. Mr. Eschweger.
We were informed by listing that it was for 2 days rather than a day and a half.
It's 1.5 days, and it has to finish lunchtime tomorrow.
Of course, my lord. May it please the court, I appear for the appellants, Mr. Bosworth and Mr. Hurley, and my learned friend, Mr. Pilbrow QC, and Mr. Heaton appear for the respondents, Farahead and the Arcadia subsidiaries. Lords, this is an appeal from the order of Sir Michael Burton and brought with the judge's permission. This is the second time this matter has come before this court. It was 5 years exactly to the day the Court of Appeal first considered my client's jurisdiction challenge. And when the parties were last before this court, the respondents accepted that Mr. Bosworth and Mr. Hurley were employees within the meaning of Section 5 of the Lugano Convention. And they maintained that position until their volte-face in oral argument in the Supreme Court. The Supreme Court made a reference to the CJEU, as your lordships know. After the CJEU gave judgment, the Supreme Court allowed the appellant's appeal subject to the question of subordination, and that question was remitted to the judge. Now, my lords, in 2015, Mr. Justice Burton held that the appellants were employees within Section 5 of the Lugano Convention for certain periods of time, and that determination was recorded in Mr. Justice Burton's order. That determination has not been disturbed by anything that the CJEU has said. 5 years later, in 2020, the same judge came to the opposite conclusion, holding there was a good arguable case the appellants were not employees. My lords, the judge was wrong and erred in the law. I have 2 grounds of appeal. First, the judge misread the CJEU judgment and did not apply the correct test to determine whether or not the appellants had a subordination relationship. In summary, I make 7 points in outline. First, the judge did not apply the relevant test. The appellants were the group CEO and CFO, and they exercised all those usual powers of a CEO and CFO. In a group company structure, the test is A, identify the group decision-making body, and B, ask whether the appellants had a non-negligible influence on that group decision-making body. 2, that subordination test is clear from the very words of the CJEU judgment in our case, and in particular from its reliance on the approach to subordination in Holtman. This very court identified 5 years ago the very passage in Holtman the CJEU has now said is the relevant test. The judge ignored Holtman. The CJEU test is not different from Holtman, as the most recent CJEU authority has now confirmed. 3, Holtman also makes clear that directors can be Section 5 employees, and so the Advocate General's distinction between employees and directors, on which so much of my learned friend's case is built, is irrelevant. 4, it is not surprising that the focus is on the group decision-making body, because the court is always looking to identify whether there is a relevant hierarchical relationship. 5. The judge asked a different question. He didn't identify the relevant hierarchical relationship between the CEO and CFO and the group board, but rather he looked at matters downstream, examining the appellant's powers, carrying out their day-to-day activities over the subsidiary companies. That was looking at the issue through the wrong prism. It necessarily ignored the hierarchical relationship. 6. The judge also failed to distinguish between the fact of a subordination relationship and the degree of supervision within such a relationship, because it's the former which is the focus of the inquiry. A light touch does not mean that there is no subordination. Otherwise, the application of Section 5 would be at the whim of the putative employer. And 7, the judge did not ask the right question, and so he could never have given the right answer. And the CJU set out the test, but its actual answer to the question could not assist the judge because it was based on a factually incomplete reference. And that was because of the respondent's late change of case. The reference did not include Farahead's instruction-giving role because that issue had never been before the National Court. And that was precisely why the Supreme Court remitted the matter to the judge to apply the CJEU test afresh. So that's the first ground of appeal. The second ground of appeal, my lord, is that the judge's test fails to satisfy the policy objective of Section 5. The relevant test has to be workable in all cases. Section 5 is mechanical. It is designed to be certain and predictable in its application. But the judge's approach arbitrarily removes numerous categories of individuals from the scope of Section 5. His approach empties the subordination test of any meaningful content, because any director, any manager, any senior individual would not be in a subordination relationship on his approach. If that had been the intention of the CJEU, it would have said so, and it did not. And it is not sufficient, my learned friends, to say that this is a factually intensive inquiry. That is inconsistent with the mechanistic nature of Section 5 and the nature of a jurisdiction challenge. And in saying that Section 5 is not mechanistic, my learned friend is making the very same error that the respondents made 5 years ago. And I'll develop that in due course. Now, the judge's errors infected his approach to the evidence. He didn't focus, as he should have done, on the pleaded case, documented employment relationship, or the contemporaneous documents. He starts from the wrong starting point. And when we look at the contemporaneous documents that the judge himself identified, in particular documents prepared by independent third parties, such as the PwC memo, documents prepared for the market, such as the information memorandum, or the group policy, which delineates the appellant's role, the position is obvious. Farahead's own tax position required it to act as the group board with executive functions. And importantly, the respondent's witness evidence does not gainsay any of those key documents.
Am I right we don't get to that if you're wrong on the question of law?
Correct, my lord. If I'm right on the question of law, then the judgment cannot stand, and then, well, in my submission, I have a complete answer to the point, but if necessary, we can go to the evidence. If I'm wrong on the law, then we don't get to that point. Yes, my lord. My lord, the burden is on the respondents to show that the appellants are not employees, and they cannot do so. So my submissions, my lord, are going to be structured as follows. First, I'm going to analyse CJEU jurisprudence and explain how the CJEU judgment relies on hot. Second, in the light of the CJEU judgment, I want to turn to the judge's reasoning and show how he misunderstood not only the CJEU judgment, but also the wider case law which bound him and with which any test must be consistent. Third, I want to address the consequences that flow from the judge's error of law. If I'm right on the law, as I said earlier, my lord, on no view can the judgment stand. And in fact, it's actually now common ground, in the light of my learned friend's submissions, that my approach would lead to a different outcome in result. And in any event, if I need to go further, then I can show the court quite quickly on the contemporaneous documents that the answer is obvious. The respondents do not have the better case, that the appellants were not employees. My Lords, Lord Justice Mayles refused me permission on paper to add a further separate round 3, which said that regardless of the correct subordination test, the judge was wrong in approach. And I'd referred to a recent Supreme Court decision in Arcadia, which concerns the approach to evidence on a jurisdiction challenge. Now, we will be looking at Arcadia in grounds 1 and 2 in any event, in the context of group companies, proportionality, and avoiding the mini-trial. And just briefly, before I move to my first main heads of submission, in terms of the context, in addition to the current English proceedings, as the court knows, there are 2 actions that the respondents have issued in Switzerland. One action, which is the mirror image of the claim here, and which has been stayed, and a second separate claim that the respondents have brought in Switzerland, and that second claim materially overlaps with many of the issues that are before this court. That claim is proceeding to trial in Switzerland next year. So, my Lords, may I first move to the CJU analysis and the jurisprudence. The relevant test, as Sir Michael Burton found at paragraph 23 of his judgment, and as is common ground, is paragraph 31 of the CJEU judgment. Just to orientate the court, if we go straight away to that judgment, it's in the supplementary bundle. In hard copy, it's the first volume, and it's tab 7. Beginning with page 85. And the relevant paragraph, which is the test.
I need electronic numbers, please, Mr. Eschwager. I don't use any paper. So is it 85 in the electronic bundle?
It should be page 85. It's tab 7 in the electronic bundle, my Lord.
Don't have tabs.
It would be page 85.
It's not. Okay.
Your Lordship should have, the electronic bundle should have tabs. If you go to the index.
It's page 19, my Lord.
Yeah,
beginning.
I'm grateful. My Lords, if we then go to paragraph 31, your Lordships will see paragraph 31, and the CJU sets out the test as is common ground. And it says, in the circumstances, it appears that Mr. Bosworth and Mr. Hurley had an ability to influence Arcadia that was not negligible, and therefore it must be concluded that there was no relationship of subordination.
Why is that the test? It doesn't look like a test to me. It's not a test. I mean, if there is a test, it's in paragraph 35. 31 is just saying that it appears that Bosworth and Hurley had an ability to influence Arcadia that was not negligible. So it had to be concluded there was no relation of subordination, irrespective of whether or not they held part of the share capital of Arcadia. That's not a test.
No, my Lord. 35 is the answer to the question. What we need to do is we will be going through the judgment very carefully to look.
Just try and answer the question, Mr. Eschwager, if you would. E31 does not state a test, does it?
My Lord, in 31, the court says that it must be concluded there was no relationship of subordination. So the test is to identify what is the relationship of subordination. How do you assess whether there's a relationship of subordination?
You have to look at this judgment in context, Mr. Eschwager. Pulling 31 out is entirely the wrong approach. Well, you have to read the whole thing, or at least this section, in its entirety to understand what it's saying. And the idea that pulling 31 out is the correct approach to a judgment, particularly at the CJU, is, to my mind, and particularly calling this a test, when it's plainly not a test, is, if I may say so, just diving in to the deep end without any regard for the rest of the pool.
My Lord, what I want to do is I want to take the court through the jurisprudence to show how the CJU judgment is built up in stages. And so we're going to be looking at this judgment in a lot of detail. But I first just want to take the court to what was common ground before the judge and what was the crucial paragraph as the judge said. So, my lord,
Judge may have said this is a crucial paragraph, but the judge quoted more paragraphs and construed them all.
Indeed, my lord, and so that's exactly what I'm going to do in due course. So, my lord, for my purposes, can we start with Halterman, and then we'll build up to see how Halterman becomes part of this judgment. And that's in the authorities bundle, my lord. And in hard copy, it's
Going to Halterman, are we?
We are, my lord. So what I want to do is I want to take the court through Halterman, show how Halterman then feeds in to the CJU judgment, and we're going to look at the CJU judgment in a lot of detail. So, my lords,
I don't know. I don't really like the suggestion that we haven't read the judgment, or that there is, as if you're telling me that we're going to look at it in more detail than we already have since we've read it. How long are your submissions intended to be? When are you going to finish your submissions?
I will finish, hopefully, I will finish mid-afternoon.
Mid-afternoon. That's satisfactory to Mr. Pilbara, is it?
My lord, that is satisfactory to me. Ultimately, it's my learned friend's appeal, and it's important that he says what he wants to say on his appeal. But there is a slightly open question, my lord, obviously. Your lordship has, of course, also my application for a further supplemental bundle that is hanging around out there, that obviously only comes into any analysis if this court considers that it needs to grapple with the facts. It's concluded that the test is wrong. It's concluded that there are no findings in the judgment, and therefore this court has got to grapple with the facts. And that is the end of my learned friend's skeleton argument. If I need to go through all of those, I need a certain amount of time too, and we will need the further supplemental bundle. If we're just focusing on the test, what is actually the test here? What's the legal question? I entirely accept, my lord, this is a more narrow and confined appeal, and it can certainly be dealt with nice and quickly. But if we do need to get into, well, the test is wrong, there aren't any findings in this judgment, that's my learned friend's position. Mr. Justice Burton didn't make any findings. Therefore, we need to revisit it all. That obviously is what would turn this into a 2-day appeal, requiring the further supplemental bundle.
Right. Well, we may have to consider. Maybe we'll do this at lunchtime. We may have to consider whether to simply have the argument on the legal point first, and see where we get to on that, rather than having hours of argument on something that may or may not be relevant. But let's allow, perhaps Mr. Eschweger, you'll stick to your legal point and let me know when you've finished that. And then we'll
I'm correct, my lord. I think that's very sensible.
Deal with it. And just to be clear, I didn't mention it at the outset, we're going to take a 5 or 10 minute break mid-morning. So again, Mr. Eschweger, if you tell me when that's appropriate, we'll do that then. Thank you.
Of course, my lord.
Halterman.
So, my lords, I've taken the court to the authorities bundle to Halterman. In the hard copy, it's bundle 2, but it's tab 22.
Really going to give me numbers. I can get to it by tab 22, but that's not the easiest way. I need electronic numbers.
So it's page 554, my lord.
Yeah, thank you.
And my lord, now the facts of Halterman are important. They were conveniently summarised by this court in Lord Justice Cross's judgment at paragraphs 52 to 54. Mr. Spies was the managing director of the Dutch company Halterman under a contract of employment. He was also a shareholder in Halterman. Halterman was purely a holding company, and it had 3 German subsidiaries, of which Mr. Spies was director and managing agent, and there were no other employees. The 4 companies brought an action against Mr. Spies for misconduct in the Netherlands, not in Germany where he was domiciled. And there were 2 sorts of claims. a breach of duty under his employment contract and company law claims against him as director. And the first issue for the CJEU was whether Mr. Spies, as director, was an employee at all. So I start with the Advocate General's opinion, my lord, and if we go to paragraph 1 and 2 of the Advocate General's opinion, he sets out the context. You see at paragraph 1 that the question for the court is in the circumstances in which a person is sued by a company for improper performance of his duties, not only in his capacity as the managing director and an employee under a contract of employment, but also in his capacity as a director from a company law perspective. We turn over the page, move through the judgment, paragraph 11, the Advocate General sets out the facts. You see that Holterman, the parent company, is purely a holding company, with the German subsidiaries underneath it. And then we turn to paragraph 26, which is where the Advocate General makes his assessment. And if you see at 26, the Advocate General asks, well, when does Section 5 cover employment contracts? And he says, at C, the decisive factor for the purposes of applying Section 5 is therefore, in my opinion, that the defendant is being sued in his capacity as party to an individual contract of employment within the meaning of the regulation. And this is in principle irrespective of the fact that a defendant may also be connected to the claimant by a legal relationship of a different kind. So it doesn't matter that Mr. Spies also has a company law relationship. Relevant question, the first question is, are you within Section 5? Then the Advocate General says at paragraph 28, he distinguishes what is an individual contract, what is a contract of employment. Now, as your lordships know, this court 5 years ago said that the Advocate General's analysis of Section 5 was, quote, striking. And what the Advocate General says at 28 is that, in my view, the differentiating factor distinguishing a contract of employment from the provision of services for the purpose of the regulation is the fact that in the case of a contract of employment, the person providing the service is to a greater or lesser degree under the power of management and instructions of the other part of the contractual relationship, which puts the former in a subordinate position vis-a-vis the latter. Then, if we turn over the page, paragraph 30, the Advocate General says this: the fact that a contract of employment may assign to a person duties associated with the management of a company does not necessarily exclude the element of subordination, although this may, in certain circumstances, be reduced or weakened in the case of managerial staff. I'm of the view that this element is present if the person who has managerial duties is under the instructions of the other contractual party or any of its organs, even if the employee enjoys substantial freedom, may have a wide decision-making power in the day-to-day performance of his duties, and does not generally act under the direct supervision of the employer. The touchstone is not your day-to-day managerial activity, because lots of senior individuals have that ability to determine their own day-to-day activities. Then 31 is important. Here, in the specific case of the managing director who acts under the instruction of the shareholders of the company he manages, I do not think the fact that the managing director is a shareholder in the company automatically means the relationship cannot be considered a contract of employment. And of course, acting under a managing director acting under the shareholders is very similar to the position in our case. What the Advocate General says is this: however, if that shareholding was so great that the person could have a decisive influence on the content of the instructions given to him by the shareholders in his capacity as managing director of the company, then in practice he would be subject to his own instructions and his own operating criteria. And in that case, I think the shareholder's power to give him directions disappears, and with it the relationship of subordination. So the key point is that the relevant question is, are you giving yourself your own instructions? 32 then, the Advocate General explains how practically the National Court can go about determining this exercise. He makes various points about looking at all the factors and circumstances. At F, he focuses on the Articles of Association and the contract. They, of course, are not the exclusive material that you need to look at. And he says that on the basis of the documents, National Court should be able to establish whether or not in the performance of his duties, Mr. Spies was acting under the direction of another organ of the company not controlled by him. In short, whether there was ultimately a relation of subordination. And then the Advocate General goes on at G and H to look at other factors that the court might take into account, and the court might consider, inter alia, from whom Mr. Spies received instructions, what their scope was, the extent to which he was bound to comply with them, who monitored his compliance, and so on. And then finally, the Advocate General says, in this context, National Court would also have to decide the extent to which any relation of subordination that may exist is affected by the fact the Managing Director is also a shareholder, as was the case here, which will in essence depend on the ability of the individual as a shareholder to influence the decisions of the organ from which he received instructions. And then finally, we go to 36, where the Advocate General makes clear at H that at the foot of the page, the special rules of conferring jurisdiction in Section 5 will apply irrespective of any relationship of a different kind that may exist between the parties, including deriving, for example, from the fact that from a company law point of view, the defendant is also a director of the company. That's what the Advocate General says on the issue. His striking analysis, as this court said, on the issue of does Section 5 apply to a director? And if we turn then to the court's judgment, which, if one turns to its, we can pick it up at page 118 in the judgment at the top of the page, and it's beginning with the first question of paragraph 34 of the judgment. The court has it. And again, the point at the outset, the relevant question is, can Mr. Spies be considered to be bound through an individual contract of employment, for the purpose of Section 5 to the company, of which he was a director and manager, and could thus be classified as a worker for the purposes of the article? The court then sets out the need to have the full effectiveness of the regulation, in 37, and then 39, the court says this: the court has already held that contracts of employment have certain particularities. They create a lasting bond which brings the worker to some extent within the organisational framework of the business or the undertaking. And note those words, bring it within the framework of the company. Those words will find an echo in the pleading that I hope to get to later on. Then paragraph 40 says that a contract of employment presupposes a relationship of subordination. And paragraph 41 identifies the essential features, just above H. The essential feature of an employment relationship is that for a certain period of time, one person performs services for and under the direction of another, in return for which he receives remuneration. So the question is, are you performing services for yourself or for another person under that person's direction? And that reflects the dichotomy that we will see in the CJEU case law between being an employee and not being an employee. If you perform services for yourself, you're self. That's the relevant distinction. Turn over the page, moving on through the judgment. At paragraph 45, the court says it's in the light of the foregoing circumstances that the referring court, the national court, must determine on the basis of the criteria set out 39 and 41 above whether Mr. Spies, in his capacity as director and manager, performed services for and under the direction of that company, in return for which he received remuneration, and was bound by a lasting bond which brought him to some extent, again, degrees, to some extent, within the framework of the business of that company. 46, more specifically, the court must in each case assess the relationship on the basis of all the facts and circumstances. And then 47, this is the paragraph that was common ground that the judge identified as the crucial paragraph, and says in turn, paragraph 23, that 31 is derived from, and obviously 31 of our judgment approves this paragraph. And what it says is this: it's for the referring court to examine the extent to which Mr. Spies, in his capacity as shareholder in Holton, was able to influence the will of that company's administrative body of which he was the manager. And in that case, it would be necessary to establish A, who had the authority to issue him with instructions, and B, to monitor their implementation. That's the first point. You look at who's got the authority to issue the instructions and to monitor their implementation. Then you go on. If it were to turn out that Mr. Spies' ability to influence that body, i.e. the decision-making body, the instruction-giving body, was not negligible, it would be appropriate to conclude that there was no relationship of subordination for the purposes of the court's case law on the definition of a worker. 48 says that if, after examining those factors, Mr. Spies has the relevant bond, then there's a contract, then there's an employment contract within the meaning of section 5. And 49 is the actual answer. In the light of all the above, the answer means that when a company sees a person who performs the duties of a director and a manager, in order to establish misconduct on the part of that person, section 5 must be interpreted as meaning that it precludes articles 5.1 and 5.3, provided that the person in his capacity as director and manager for a certain period of time performs services for and under the direction of that company. So so what you get from Holton is 2 points. First, we can see from 47 what the actual test of subordination is. You're looking at the decision-making body that gives instructions, and you're asking, does the individual have an ability to influence that body? And the reason for that is if you can influence that body to a non-negligible extent, then the individual, in effect, is giving himself his own instructions. And the second point you get from Holton is that Holton, in terms, the company law analysis about a director is irrelevant to section 5. Now, it's against that backdrop that I want to turn to the judgment in our case, which is back in the supplemental bundle. I believe it's page 90, it's tab 7 for those in hard copy. I'm going to start with the Advocate General's opinion.
Just before you do that,
Of course.
Mr. Eschwege, if we go back to paragraph 47,
Yes.
it's for the referring court to examine the extent to which Mr. Spies, in his capacity as a shareholder, was able to influence the will of that company's administrative body of which he was the manager.
Yes.
So that's looking to the company by which he was employed to be the manager, right?
Correct, the manager of the company. But remember, my lord, this is Holton is the parent company.
I understand Holton is the parent company, but he was the manager, was he not, of Holton?
Correct, yes, ma'am.
And in that case, it would be necessary to establish who had authority to issue with him instructions and to monitor their implementation in his performance as manager of that company.
Correct, ma'am.
That's all I wanted to be clear.
Of course. And if we then turn to the supplemental bundle to our judgment in our case, it's tab 7 hard copy, it's 90, I understand, in the electronic version. And we begin with the Advocate General's opinion. And I can take that relatively briefly, because as the court knows, the court does not adopt the Advocate General's approach. But we need to examine what the Advocate General says, because I want to contrast what the Advocate General was doing with what the court was doing. So to turn to the Advocate General's opinion, and if we turn first to paragraph 17 of his opinion, which is, it's 512 in the report, and it simply sets out the question. And I just take the court to the foot of the page, 512 in the report, question 2, and you see he sets out the question: can a relationship exist where the individual is able to determine and does determine the terms of his contract with the company and has control and autonomy over the day-to-day operation of the company's business and the performance of his own duties, but the shareholders of the company have the power to procure the termination of the relationship. So that's the only qualification in the question. The only thing that CJAU is looking at is what happens, does it make a difference if a shareholder has this single power to terminate the relationship. We move on to the Advocate General's opinion. After some preliminary remarks, at paragraph 26, which is 515 in the report, the Advocate General sets out the second question. And he says, in the middle of that paragraph, it raises the question whether such a relationship can exist when the individual decides on the terms of his contract and has, quote, full control and autonomy over the day-to-day operation of the company's business and the performance of his own duties, while the shareholders of the company have the power to terminate the contract. Now, that is the Advocate General's understanding of the question. He says full control. And that was to misunderstand the premise of the question, because the evidence actually is that Mr. Bosworth and Hurley did not have full control and autonomy. But it's revealing that the Advocate General talks in those terms because he understands the question in effect to say Bosworth and Hurley give themselves their own instructions. Let's move on to the substance of the Advocate General's opinion. And the first point, which we can pick up, it's at paragraph 34, and it's a simple point that, as is clear from Holterman, one have a contract of employment for the reasons set out in Holterman, such a contract exists once the features of an employment relationship are factually present. And he goes on, the fact that you don't have a contract, if you like domestic law terms, doesn't matter. What matters is the employment relationship, and it can be a de facto one. And that's going to be important for my group company point, which I'm going to come on to, and which is also relevant to how you need to understand paragraph 47. The Advocate General then moves on to pick it up really at 41. He refers to Holterman. He says there, the court held for the purposes of section 5, the question is, does a relationship of subordination exist in each case on the basis of all the facts and circumstances? The court also stated that a director holding a sufficient share of capital to influence in a non-negligible manner the persons normally competent to give him instruction and to supervise their implementation cannot be subordinate to the company. So that's how the Advocate General understands paragraph 47. And in my submission, the way you put it, who's giving you instruction, what's the decision-making body, who's giving you instructions, is precisely what the Advocate General also understands Holterman is doing. 2, however, what the Advocate General says is it doesn't matter. It doesn't matter whether or not the officer has a shareholding in the relevant company. He says that can't matter. He then looks at how you determine an employee. 43. First, you draw on the court's case law on the concept of worker within the meaning of Article 45 and various other directives. And he sets out what that case law says. And then in 44, he says it follows that a company director is subordinate to the company only if he is subject to the effective direction of another person in the exercise and organisation of his duties. And the existence of such a direction is assessed in the light of the nature of the functions in question. Then, at 45, he draws the contrast between the concept of employee that he set out and what he understands the reference to state. And he says, well, given what the reference says, these directors enjoy the broadest powers in managing the company and enacting the name of and on behalf of the company. And therefore, he says, they're not subordinate. In 46, then, he addresses the point that had been raised in the question. Does it make a difference if the shareholders have the power to harm or fire? And what he does is he draws a distinction between what he calls general directives that concern the orientation of the company's business and control mechanisms on the one hand, and on the other hand, whether or not the shareholder or the entity is involved in directing the company. You see that if you turn over the page, just the last few lines of 46. I'm going to come back to this when we get to the judgment, because the judgment refers to this paragraph. For the moment, just if the court can see 4 lines from the foot of 46, the fact that they, the shareholders, have such a power of revocation does not mean they have involved themselves in the way of directing the company. That's the distinction that's being drawn. The Advocate General then moves on to analyse employee versus director. And he says, in effect, that if you're a director, your liability arises under company law, and therefore you can't be within Section 5. You pick that up, for example, at paragraphs 52 and 53. The problem with the Advocate General's analysis is that the CJEU, in its judgment, does not say this. And more importantly, it is totally contrary to Holtman. As we saw, Holtman said in terms, it doesn't matter that the individual has another legal relationship with the company. What matters is whether you're within Section 5. So the Advocate General's distinction between employee and company law, which he builds all the way through to 59, is irrelevant. It is contrary to Holtman. And whatever might be said about our CJEU judgment, it does not say that Holtman is wrong. The Advocate General also ignores other cases that said in terms that a director could be an employee, in particular a case called Denosa and Balkaya, which are in the bundles and we may get to later. And he says there, well, the distinction is those cases all concern whether the individual was a worker for the purposes of various directives. But there's a problem with his analysis, because you recall that a few paragraphs earlier, the Advocate General will say that you draw on the concept of worker in those cases to understand who is an employee. But the position is actually now, in my submission, beyond doubt. Because last week, I sent to the court the most recent authority, that, as I understand it, that deals with Section 5. And it is, it's the second authority, it's in the authorities bundle, the last tab 30, which is 757. This is a case called BU and Marked. It must have been published only very recently, or it was handed down earlier. And I came across it last week, and it's about Section 5, and it also includes an opinion from the very same Advocate General. And just to orientate the court, the particular issue here was whether the putative employee could sue her employer in circumstances where she had never actually performed any work. And the court needed to consider, does Section 5 apply? And all I need to do for my purposes, in the Advocate General's opinion, is just go to page 333, which is paragraph 20 of the opinion, where the Advocate General says, looking at Section 5, it should be noted at this stage that Section 5, contains rules specific to proceedings concerning individual contracts of employment. Those rules, which have already given rise to consistent case law, are intended inter alia to protect workers. And he goes on, he makes the same point. If we go to paragraph 35, which is page 336 of the opinion, where he says the whole objective of Section 5 is protecting workers. So whatever the Advocate General might have said in Bosworth about trying to say you don't look at case law on workers, or you can draw a distinction between company law and employee law, none of that holds water. He has himself said you draw on the concept of the worker case law. And that is another answer to what my learned friend says in his submissions. Can we go back to the Advocate General's opinion in Bosworth? And we were at 47 and following, where he gives his distinction from company law and employee. He then answers the questions about action before the National Court, and by and large, he says that the appellants were correct.
Mr. Ashfigger,
yes, of course.
Are you going to go back to being unmarked, or is that what you wanted it for?
I will be going. There is one other paragraph I will be going back to. If we're there now, it's paragraph 25 of the judgment, my lord.
Yes, I just wanted to ask you a question.
Of course.
That was not a case which raised any question of subordination.
Well, it did. It raised the question. It raised the question. It presupposed subordination. The question was, are we in Section 5? And what the court says at paragraph 25, which I was going to go to, of the judgment, is that, as is apparent from the court's case law, that concept, Section 5, presupposes a relationship of subordination of the employee to the employer, and it sets out the essential features. And then can the court see by analogy, Holtman and Bosworth? So what the court is saying is that Holtman and Bosworth, they sing from the same hymn sheet. That whatever the test, and we can come back to the test, it's the same test. So when my learned friend says in his submissions that Bosworth has moved the test on, or that what he calls the Holtman test isn't the Bosworth test, that is not correct. The court says in BU Marked it's consistent case law, and at 25, when it's looking at the essential features of an employment relationship, it cites Holtman and Bosworth.
What it cites is paragraphs 40 and 41 of Holtman.
Yes.
And paragraphs 25 and 26.
Correct.
Bosworth, which, as I understand it, are authority for the proposition that the EU autonomous concept of employment relationship requires three things: provision of services, remuneration, and subordination. And that's all it's authority for, and that's not in dispute. It's not a reference to how you decide.
It's not a reference to how you decide subordination. What it does show is that the court is not saying, as my learned friend said, that Bosworth is somehow different from Holtman in its approach. And I'm going to make that good when we come to the judgment now, in a moment.
Can I take it there was no question in Biu and Mark as to how you determine the question of subordination.
That's correct. There was no, in that case, yes.
Thank you. Very helpful.
My Lord, can we go back to the Advocate General's opinion in our case? And the only other point I want to raise on it is what I would call the group company, which you see beginning at paragraph 104 of his opinion to 1110, which is page 532 of the report. And it's really 109. And and as the court will appreciate, we're in a group company situation. The question has always been, if there aren't, if you like, domestic contracts of employment with the other companies in the group, does that mean Section 5 doesn't apply when those other companies bring claims? And our case has always been no, because we're in a group company situation. We referred previously to Petter and Semengo Turner, and on the basis that you always look at reality, not the form. And the question is there an employment relationship within the group? What the Advocate General says here, 109, at the top of page 533, he endorses what Petter and Semengo Turner was saying. Top of page, companies belonging to the same group should be subject to the same jurisdictional restrictions. And of course that's obvious, because otherwise, if you're in a group company situation, you'd be able to evade Section 5. That's all I want to say on the Advocate General. Turn then to the judgment. We begin at page 535.
Just before you leave that, trying to apply that to our case, we've got 4 claimants.
Yes.
There's 3 Arcadia companies, the first 3 claimants.
Yes.
I assume that your submission is they're in the same group. In fact, I think that's common ground.
They are called the Arcadia Group. All the claimants in my submission are the same group.
Well, I was going to ask you that. Do you say that Farahead is part of the Arcadia Group?
It's part of the same group of companies.
What group of companies is that?
The Farahead Group, my lord. And we will see in the documents that what is called the Arcadia Group is in fact the Farahead Group. Because that's how it is looked at. Farahead is the holding company, the parent company, and it has subsidiaries. And when we look at the structure, the way this group is organised is, if you like, by function. So you've got functions, different units, that all funnel up to the group board, Farahead. So that's why I say, my lord, that Farahead is within the group. And that is also, in my submission, when we come to it, how the CJEU is looking at the position. And explains its language in 31, which I'm going to develop that in a minute. So, my lords, if we start at paragraph 6 of the judgment, where the CJEU sets out the companies, the Arcadia Group companies, owned 100% by Farahead. And then 7, it notes that Bosworth and Hurley are CEO and CFO of the group, and also directors. Then 8, by an application, 12th of February, Arcadia London, Arcadia Singapore, Arcadia Switzerland, and Farahead, together, Arcadia, commence proceedings. So when the court talks about Arcadia, it is not talking about the subsidiaries, it is talking about the group, the claimants as a whole. Arcadia sought compensation from damage which the Arcadia Group claimed and sustained as a result of fraudulent transactions. And then 9, proceedings brought by Arcadia. Then the CJEU sets out over the page the question, and again, the question is very important. All the CJEU does is it answers the particular question. It doesn't go any further, and you can see, again, we saw this earlier, question 2, the only relevant issue, question 2, does it make a difference if the shareholder has the power to hire and fire? Then we turn over to the second question, which is page 538 of the report.
I'm sorry, I don't understand that. I thought there were two questions in sub 2. If a company and an individual enter into a contract, to what extent is it necessary for
Yes.
the relationship subordination between the company and the individual for that contract to constitute an individual contract of employment? First question. Can such a relationship exist where the individual is able to determine and does determine the terms of his contract with the company and has control and autonomy over the day-to-day operation of the company's business and the performance of his own duties, but the shareholder has power to procure the termination? Second question.
I took it too quickly. Your Lord is entirely correct.
Thank you.
The relevant question is the second question.
Well, they're both answered.
Yes. If we turn then to paragraph, the analysis of the second question, which is page 538 of the report. And the court begins by asking, at paragraph 23, are Bosworth and Hurley parties to an individual contract of employment? And you see at the foot of the page, see to that effect, Holterman. Paragraph 24 goes on. In that regard, classification cannot be determined on the basis of national law. Holterman. You need to give independent interpretation. Holterman again. And then we come to paragraph 20, should be paragraph 25, it's misnumbered 24. And here the court turns to the concept of employee. The concept. It must be recalled, as the court has consistently held, the concept must be defined in accordance with objective criteria, which distinguish the employment relationship by reference to the rights and duties of the persons concerned. And the essential features, for a certain period of time, the person performs services for and under the direction of another person, in return for which he receives remuneration. And the court then cites the judgment Kiski 25 and the case law cited. Now, my lords, we have Kiski in the bundle. It is a case about employment law and the concept of worker. In fact, it's about a particular directive on worker that is the very same directive that is also at issue in Denosa. So when my learned friend says in his submission that the CJAU ignores or omits the case law on worker, that is not correct. In the very paragraph about the concept of employee, the court is approving Kiski and the case law cited, case law on worker. 26. And that is actually made good by the next paragraph, the next 2 lines of the paragraph, which say, an employment relationship implies the existence of a hierarchical relationship between the worker and his employer. And that is to be assessed on the basis of all the factors and circumstances. A reference again then to Holterman and to another case which concerns, if you like, a worker, syndicatal. Then 27, that makes the point that you don't need a formal contract. And then 28, you need a relationship of subordination. Then we come to the present case. What does the CJAU take from the question and the reference? In 29 and 30, it sets out what the information provided to it in the reference. Makes the point that the formal contracts of employment are drafted by Bosworth and Hurley at their direction, and they act at all times on behalf of the group companies. And then at 30, it says it is also apparent from the reference that Bosworth and Hurley exercised control over by whom, where, and on what terms they were employed. Now that reference came originally from a gloss that this court had said that Mr. Justice Burton had found. But whatever was in the reference is not actually informative, in that the whole point of the remission to the judge was to remedy the factual basis of the incomplete reference. That's why the Supreme Court allowed the remission. It was not saying, well, the CJU has answered the question, we don't need to look at it further. The Supreme Court recognised that the reference had been incomplete. It was incomplete because of the respondent's late change of case. And then we come to paragraph 31. And it starts in the circumstances. So it's looked at the reference and it's coming in the circumstances. How do we apply what we see in the reference to what is before us with the relevant test? In the circumstances, it appears Bosworth and Hurley had an ability to influence Arcadia, not the Arcadia Group, not the Arcadia subsidiaries, Arcadia, all four claimants. That was not negligible. And therefore, it must be concluded there was no relation of subordination. See, to that effect, Holtman 47. And that applies irrespective of whether or not the appellants held part of the share capital in Arcadia. So in my respectful submission, 31 is setting the subordination test because it refers expressly to what we saw in Holtman, which said, how do you determine whether or not an individual with managerial duties is subordinate? There are two stages: decision-making body, are you able to influence that body? And 31 is taking that very language, non-negligible language, saying, look at Holtman and saying, in these circumstances, given what we've seen on the reference, subordination is not made out. But look at the reference to Arcadia. It's all claimants. So 3 points follow in my submission on 31. The first is the reference to Arcadia, not the subsidiaries. Arcadia includes Farahead. And there's a reason why the court is referring to Arcadia, because the CJU is looking at the group as a whole, parents and subsidiaries, just like in Holtman. Holtman was purely the holding company and had the German subsidiaries, and the court looked at the whole. And of course, it's obvious why you've got to look at the whole, because this is a group company perspective. If you don't look at the whole, then of course, the holding company, the putative employer, could simply evade Section 5. The second point is that this test applies irrespective of whether or not Bosworth and Hurley had shareholding. CJU recognised that in Holtman, the question there was, did Mr. Spies have a shareholding in Holtman? And here the court says that doesn't matter. So what the court is saying in 31 is what we said in Holtman applies irrespective, i.e. the test in Holtman, the approach in Holtman applies irrespective of whether or not you've got shareholding. It applies in this case as well. And the third point that we gave from 31 is that this paragraph 31 is not the approach of the Advocate General. We saw that his approach was to ask about total control and autonomy over your day-to-day performance of your duties. And the court does not say that is the approach. Now, nowhere in my learned friend's very lengthy submission does he address the language of paragraph 31. That language is impossible to square with his case. At first instance, he had accepted that the critical inquiry was to look at Farahead. He said that in his skeleton, paragraph 32 before the judge. On appeal, he now shifts ground, and he says in the skeleton, well, the question for the judge was negligible influence over, quote, the Arcadia Group. That is not what paragraph 31 says. It's Arcadia, not the Arcadia Group. He also says that the CJU is not asking any question about Farahead in 31. That also is impossible as a matter of language to sustain. We move then to 32.
Before you do that, you said I think a little while ago, that 31 is not asking any question about day-to-day performance, total control and autonomy over your day-to-day duties. But I thought paragraph 47 in Holterman said it'll be necessary to establish who had authority to issue him with instructions and to monitor their implementation, i.e. over day-to-day affairs.
47 is saying that you ask, first of all, who gives you your instructions to carry out your role? And in my submission, that's what they call the administrative body, the decision-making body, in respect of the performance of your duty. Yes, I agree with that one. But the key point, and this is crucial, is you're looking at the body that gives instruction. If the decision-making body licenses the individual, permits a degree of autonomy, that still means there's subordination. And that has to be the case, because otherwise, any individual who has any senior role in any company would never be subordinate.
We only have an amount of subordination that's not negligible.
No, my lord, you've got to have a non-negligible influence over
Non-negligible influence.
Not on subordination, but on the decision-making body, because that's, if you like, the source of your instruction, of your instruction giving the function. That you receive your instructions from, if you like, what I call the group board, what Holterman calls the administrative body. It directs the company. And the issue is, when the individual carries out his tasks, is he doing it with the license of the decision-making body in accordance with those instructions, or is he giving himself his own instructions? 32 of the judgment then addresses the particular issue in the question, which was, does it matter that the shareholders have the power to hire or fire? And what it says is the fact that Bosworth and Hurley are answerable to the Arcadia Group's shareholders, who through Farahead have power to hire and fire, is irrelevant. So there's 2 points to pick up here. The first point is this is the only power of the shareholder that is said to be irrelevant, the power to hire and fire. And the second point, again, the language of the judgment, it refers to the shareholders through Farahead. This paragraph is not concerned about Farahead qua shareholder, it's about the shareholders who stand behind Farahead. And that's important because the court is looking at the group as a whole. That's why Farahead was in 31.
Sorry, I don't understand that quite, Mr. Schroeder. Suppose instead of Farahead Holdings,
Yes.
which is a company put into the structure whose shares are ultimately held by trust and settled by Mr. Fredriksen. Suppose Mr. Fredriksen had held the shares in all the Arcadia companies himself. What difference would it make to the amounts?
The difference is that what 32 is not saying is that you ignore, if you like, the group board or the decision-making board that also is the shareholder. Your Lord is right that ultimately it doesn't matter whether it's Mr. Fredriksen or Farahead who has the power to hire or fire. So I agree with your Lordship on that. But the point that is being made in 32 is it's looking at Farahead qua shareholder. It is not saying anything else about Farahead.
Well, it's answering the question that was referred, which is, does it matter that the shareholders have the ability to terminate the relationship?
Yes.
The shareholders of the company have the power to procure the termination of the relationship. It's not saying anything, as I read, about other powers that Farahead or Mr. Fredriksen or anybody else might have. I don't think it's endorsing your suggestion that what's relevant is what you call the decision-making body. All it's doing is answering the question: does the fact that the shareholders, whether it be Mr. Fredriksen directly or trustees of offshore trusts or Farahead, does it matter that they can fire the directors? And they say no.
I agree with that, my lord. It's not saying anything more than that. I totally agree with your lordship. Then in 33, having said that the power to hire and fire is irrelevant, 33 then explains, well, why is it irrelevant? And at this point, the court refers back to 46 of the opinion and says at 33, neither the general directives which a director may be given by the shareholders of the company he directs for the orientation of the company's business, nor the legal mechanisms for control point in themselves to the existence of a relation of subordination. And therefore, the mere fact that shareholders have power to revoke a directorship is not sufficient for the conclusion to be drawn that such a relationship exists. Now, the context here is explaining why the shareholder power to hire and fire is not relevant. And you see that what the court has done is it says, well, a shareholder could have what it calls a general directive for the orientation of the company's business. Now, in my submission, a general directive is one, about the orientation of the company's business, two, does not concern the performance of a director's duties, and three, does not involve directing the company. And your lordships may recall that 46 of the Advocate General had said the question was, are you directing the company? So what a general directive could be, is it could be, for example, high-level guidance to a director, make the company carbon neutral. What it is not is a mandatory command, do this or do that in respect of your duties. If we're in the world of mandatory commands or requirements, then that's not a general directive, because that's about directing the director in the performance of his duties. Then legal mechanisms of control would be the power under the articles to dismiss the director.
I'm sorry, Mr. Fredriksen.
Yes.
I think you'll need to explain what you mean by general directive a bit more.
Yes, of course.
If one looks at the Attorney General of paragraph 46, it seems what he had in mind was that the owners of the company give the directors what he calls instructions regarding his mission. You know, your job is to carry out trading in oil products in the United States or in West Africa or whatever. And they can presumably set quite a lot of the directions around that mission. What they're not doing is telling the director how to do what they've told him to do. So I don't find it easy to say, as soon as you get him to do this or do that, we're outside a general directive. The directive is telling you what to do, but in general terms, isn't it?
The distinction, my lord, is between whether the director is required to act in a certain way in the performance of his duties. So if you're required to act in a certain way, then that is not a general directive, because at that point, what is happening, as you can see from what the Advocate General was saying, is that if you give a mandatory command, you are involving yourselves in the way of directing the company. And that's the key point. The Advocate General is thinking, as your lordship rightly says, about regarding the mission, act in the company's interest. Again, make the company carbon neutral, make lots of money for the company. At a general level, that's a general directive. But as soon as you require the individual to act in a certain way, and the key is require, then that cannot be a general directive, because you're looking at how the shareholder has in effect involved himself in directing the company. And it doesn't matter whether it's the shareholder, it could be any entity. I say it's the group board. That doesn't matter, because as soon as you're directing the company, you're giving instructions to the individual, and it's the instruction-giving role that identifies whether there is subordination. The reasonable instructions regarding his mission are this high level, has to be this high level guidance to the company, not to the director. To the company, not the director.
I'm not sure how far one can take these very generalized distinctions. I mean, everything will depend on the particular governing instruments of the company in question. I mean, do you have a standard form article provision in the article saying that the board of directors has the general duty and power to carry on the day-to-day business or not? And what the shareholders are able to do will again depend on looking at the articles and so forth. So, I mean, all these points are very, very high-level ones, aren't they? And the point about shareholder control is it's always there in the background. The shareholders can bring about a change of regime if they exercise their powers to change the directors. But subject to that, they need to be kept informed, and they have powers, no doubt, to give advice and so forth of the kind you've been taking. But I'm really just wondering how far one can draw a clear-cut distinction.
My Lord, I agree with you entirely. It's very important not to get drawn into the language of the Advocate General uses, which is not clear. It is, as your Lordship says, ultimately, when you look at the material, what happens in practice. So I agree with the Lordship completely. What I'm trying to do is simply, if there has to be a distinction, then that, in my submission, would be the distinction. It's my learned friend, of course, who relies on the distinction because he effectively says anything Farahead does would be a general directive. And I say that's not correct. I'm reminded that it might be a convenient time for a 5-minute break.
Yes, we'll break until 11:55.
I'm grateful.
Sorry, just checking that we've got Lord Justice Henderson.
Yes, sorry.
No, that's fine. Mr. Edberger, please continue.
I'm grateful, my lord. We were looking at paragraph 33, and obviously 33 has to be read together with 31 and 32, and in all cases what you're doing is you're identifying the instruction-giving body of the group, and you're asking, that's the body that gives instructions, has the executive functions, and you're asking, does the individual have a non-negligible influence on that body? And the fact that Holtman, Mr. Spies was managing director of the parent is neither here nor there, because as we know, in a group situation, you're looking at the reality, not the form. My lords, let's move on then to 34, where the court says it follows from their above analysis that a contract concluded between a company and the director of that company does not constitute, in circumstances such as those at issue in the main proceedings, a Section 5 contract of employment. And they say in the circumstances such as those at issue because the CJU is looking at the reference and the factual basis in the reference. And the problem with 34 was the reference was incomplete. I need to explain very quickly why. The reference had been based on the agreed statement of facts before the Supreme Court. At that point in time, there'd been no issue that Bosworth and Hurley were not employees. As to Farahead, the only thing that had been said about its power was the power to hire and fire. That was the only power identified in the agreed statement of facts. And had been drafted on the basis of the respondent's concession to this court in 2016. But Farahead's role went beyond merely the power to hire and fire. It also included mandatory instructions in respect of the director's duties. Do this or do that. And in the Supreme Court, it had been the understanding of everyone that Farahead had the instruction-giving role. That was certainly your assumptions understanding, which we have in the bundle. We need to go to it, and the respondents did not do it. The CJU did not know that A, Farahead had the power to instruct the appellants do this or do that. They did not know that the appellants had no ability to influence Farahead. They did not know that Farahead acted as the group board. They did not know the appellants had to report on a regular basis to Farahead. They did not know that the subsidiary boards were neutered at Farahead's direction. They did not know that the Arcadia Group accounts were consolidated with those of Farahead, because we are talking about the Farahead Group. And it was because the reference was incomplete, and the Supreme Court recognised that it made the remission to the judge. 35 says, having regard to the above, so it's the conclusion, it then gives the answer. And it answers directly, it frames, in terms of the relevant question. But of course, its answer to that question is not actually the analysis. The analysis we've already seen in 31 to 33. And at this point, I should probably very briefly address what the respondents say about 31 and 33, and in particular my reliance on Holtman. They have no answer to the fact that 31 says in terms C to that effect, Holtman 47. They try to disparage my position by saying, well, you're talking about the Holtman test, Bosworth test is different. In my submission, that is not correct. Holtman and Bosworth say the same thing. We haven't moved on. My learned friend also said that the test is one of managerial authority. That is not correct. That's what the Advocate General said was the relevant approach, and it's not adopted by the court. The court rather looks at, do you have the ability to influence the body that is ultimately the executive board of the company, the group, so on. My lords, Once the CJU judgment is correctly read and understood, the judge's error in our case is obvious. And I want to turn now to the judgment, which is in the core bundle.
But before you do that, Mr. Fredriksen, did you deal with paragraph 35? Sorry.
Yes, my lord. So paragraph 35 is simply the response to the question. So what 35 is doing is it picks up the terms of the question and it says, here is our answer. What 35, having regard to the above, means is having regard to our above analysis. 35 is not in and of itself actually any analysis. That's why it's not correct to say that 35 sets the, if you like, the test, the relevant approach. That's the key point. The approach is in 31. And that was what the judge had to apply. I mean, he recognised that, yes.
I mean, 35 is the answer to the question that the Supreme Court asked. That's what it's doing.
Yes.
Now, you said when we were going through 31 that there was nothing in there about day-to-day operation and autonomy, which was something that the Attorney General had referred to, but the Court of Justice itself had not referred to. But can you explain what then that is doing in 35, reference to day-to-day operation, control and autonomy of the day-to-day operation?
The question, we start with the question. The question said, these individuals have control over and determine the terms of their contract and have autonomy over the day-to-day operation of their business. So that's where the reference comes from. It comes from the relevant question. That assumes that they give themselves their own instructions. That's the point. That's where this case has gone wrong. Because we had an incomplete reference, because the reference does not say Farahead also had this instruction giving role, it leaps, if you like, to the second part of the Halterman test, or the Halterman approach, i.e., is there an ability to implement your own instruction? It doesn't address the first part of the approach, i.e., identify the decision-making body. So when the court says in 35, here, there's no subordination because the directors have the ability to determine their contract and have control and autonomy. All they are doing is picking up the way the question was itself framed, which used those words in terms.
They're answering the question, aren't they, Mr.
Exactly. Yes, exactly.
They're answering the question and telling you what you have to look at and what the answer is. And the answer is that even if the shareholders have the power to procure termination, that person is able to determine, or does determine, the terms of his contract and has control over his day-to-day operation of that company's business and the performance of his own duties. And that does not create a relationship of subordination. And what I don't understand is that it's got to be not negligible, the non-subordination. And you have to say that all that is completely irrelevant if there is a person who has power over you to do more than hire and fire, but also to give you instructions which actually he doesn't give in relation to the business of Arcadia. And by Arcadia, I mean the trading company is not the head company. So I just don't understand how that can be the case. I mean, nobody would be excluded from this. This is about workers. This is the whole point here, is that this structure is to give protection to people who are workers, who need protection. And the persons we're dealing with here were running the show. And that's what this paragraph says and explains.
My lord,
I mean, it's just you engage in this incredible, if I may say so, micro-analysis of this text as if it were a deed. And we know that Court of Justice decisions are not a deed. They also don't spring off one and another like a doctrine of precedent we have in England. It's a completely different process. And undergoing this process of meticulous examination completely obfuscates the real test, which is, were you in charge? Yes, you were. That's what the judge found. I just don't, at the moment, I just don't see what Mr. Farahead or Mr. Fredriksen having some putative power to do away with you or to give you instructions which he didn't give as to how you ran the company of Arcadia, not Farahead, gets you anywhere. I mean, it just seems to me that it's some intellectual analysis that you can say, got you. This is what you're doing. You know, taking words used in an imprecise way and saying, got you, and ignoring the ones you don't like, aren't you?
My lord, I'm not ignoring words I don't like. What I'm trying to do...
You just ignored para 35 completely.
No, my lord, the 35 is the answer to the question, but it's not the analysis that the question said that the individuals have control and autonomy over their day-to-day duties. 35 answers that question, but the approach is in 31. And it's not correct to say that Section 5 is about workers, not directors. Halterman says precisely the opposite, and this court and the learned judge were bound by Halterman as much as they were bound by Bosworth. This court, 5 years ago, identified paragraph 47 as the relevant subordination approach. CJAU, in my submission, has confirmed that is the approach. And so what the learned judge had to do was apply that test in Halterman 47, Bosworth 31, to the material before him. And once you understand that 47 is asking about the decision-making body, is there non-negligible influence over that body? You then see, in my submission, that there is, in this instance, subordination, because otherwise, and this is really my ground too, any senior individual would always fall outside Section 5. Because if you take the learned judge's approach, which is simply power over the company, that would mean any manager would be outside Section 5, any senior manager. And that's
Why? I don't understand that. I'm looking at the way in which Sir Michael Burton put it.
Yes.
And he says at paragraph 26, the evidence was addressed to the question whether, as the claimant said, your clients called the shots and ran the companies, or whether, as you said, no, we didn't. We were told what to do by Mr. Fredriksen. Now that's a perfectly understandable question. You can have companies like this where the CEO and CFO between them run the company and are left to get on with it. You can have others in which the owners interfere all the time and tell the CEO and CFO exactly what to do. And that was the question Sir Michael Burton looked at. So why does it follow that looking at that question automatically places senior employees into a position where they never have to benefit from Article 18.1? I simply don't see that.
Lord Justice Sales in Petter said that Section 5 was not about an individualised assessment. You're looking at, are you an employee or are you not an employee? What the learned judge did here, and we're going to come to this in a moment, in paragraphs, say, 21 and 24, is he ignores Farahead as the group body. And that is because he did not appreciate what Halterman was doing. And I can make, perhaps I should move to those submissions now, look at the judgment and show where the judge went wrong. So, my lords, if we're with the judgment, if we start with paragraph 14 of the judgment. Yes, of the main judgment. And we begin at paragraph 14. The judge, having looked at various preliminary points, refers straight away to Halterman, and he says it was only 2 paragraphs of Halterman which were expressly approved by the CJAU. 46 and 47. And then we go on. He records the various submissions, paragraph 16, 17 and following. At the foot of paragraph 20, he talks about the reliance on the Advocate General's reasoning, effectively the employee-director distinction, which is just wrong in law, because Halterman tells us otherwise.
So,
And then,
which passage is wrong in law, please?
so, at the foot of paragraph 20, what had happened, if you turn back the page, your lordships will see that the judge refers to my learned friend's submission that to understand 46 of the Advocate General, you've got to look at what followed 46. You see 52 to 59. And that was the analysis the Advocate General made between directors and employees. And then the judge says, these paragraphs were not adopted by the CJEU.
Sorry, where are you reading?
Oh, I beg your pardon, the foot of paragraph 20, after the quotation.
Yes, and this is what you said is wrong in law.
So what the judge says, these paragraphs were not adopted by the CJEU, but plainly constitute the reason for the Advocate General's conclusion, which was adopted by the CJEU. So he suggests, Judge,
Is that wrong in law?
Insofar as the Advocate General was drawing a distinction between employees and directors, that is wrong in law, because Halterman has told us otherwise. We saw in Halterman there were two sorts of claims, employment law claims and company law claims. And the court says expressly, it doesn't matter what relationship you might have as a company law director if you're within Section 5. That's why the distinction that the Advocate General drew was not correct. And in any event, it's not what the CJEU is saying in our case. The judge, in his judgment, did not apply the test that he was asked by the Supreme Court to do. And the reason he didn't do so was for at least 6 reasons.
Right, can we look at what he was asked by the Supreme Court to do?
Yes, of course. So that is in the supplemental bundle, in hard copy, the first bundle, and it's tab 8, which is page 127, I'm told, in PDF. It's 122 in the bundle reference, and this is the order from the Supreme Court. And you see the court ordered the appeal be allowed, but only to the extent of remitting the commercial court to hear further submissions on whether the appellants were, quote, in a relationship of subordination to their employing company or companies in the...
I haven't got the right... which bundle are we in?
We're in a supplementary bundle, the first volume, supplementary bundle, the main supplementary bundle.
Page
127 in the PDF.
Okay, got it, thank you.
And it's paragraph 1. The appeal be allowed, but only to the extent of remitting the case to the commercial court to hear further evidence and submissions on whether the appellants were in a relationship of subordination to their employing company or companies in the sense used by the Court of Justice of the European Union in its judgment. So as to place...
Can I ask you, who do you say the employing company or companies were?
The official employing company.
No, not the official one, in that question.
The group. And that is because...
Including Farahead?
You can be an employer without having a contract of employment. That is well established.
No, we're not talking about your, if I may say so, convoluted arguments. We're talking about whether or not who was the employing company or companies in the sense used by the CJEU in its judgment of the 11th of April 2019. My Lord has asked you that, and the answer to that is Arcadia, isn't it? It's not fact
It's the Arcadia subsidiaries. They have the official contracts of employment with the appellants.
Yeah, the answer to the question is that what the Supreme Court was ordering is that the case be remitted to the Commercial Court to hear further evidence and submissions on whether the appellants were in a relationship of subordination to their employing company or companies in the sense used by the Court of Justice, namely Arcadia, the subsidiaries. That is what they remitted.
My lord, employing company means employer. And you can be an employer without having a contract of employment.
Again, you've got to address the question the court's asking you. In the sense used by the Court of Justice in its judgment meant Arcadia, didn't it? If not, please show me in the judgment where it says that the employing companies were Farahead or somebody other than Arcadia.
By Arcadia, my lord, you mean the Arcadia subsidiary?
I mean the subsidiaries, yes. The person with whom the contract of employment was entered into.
The domestic contract of employment.
Yes.
Because we see from paragraph 27 of the judgment, which we looked at earlier, that what matters is not the domestic contract, it's the employment relationship.
Okay, can I ask you a different question, Mr. Eschweger? We know that it was common ground before the Supreme Court that Mr. Bosworth and Mr. Hurley were respectively de facto Chief Executive and Chief Financial Officers of the Arcadia subsidiaries. There's no agreed fact that they were CEO or CFO of Farahead. They had no position in Farahead at all, did they?
Correct, they have no position in Farahead. They are
Can I stop you there? We know from the consistent jurisprudence of the Court of Justice that for European purposes, not domestic purposes, for European purposes, a contract of employment requires three things: the provision of services in return for remuneration to a person under whose direction you act, to whom you are subordinate. The services provided by Mr. Bosworth and Mr. Hurley were not Farahead. They were to the three Arcadia companies. Is that not right?
The services were provided to the companies at Farahead's request because Bosworth and Hurley have a group role.
Yes, you're not answering the question, Mr. Eschweger. For European law purposes of what an employment relationship is, you have to provide services to another person under whose direction you act. Is it your case that Mr. Hurley and Mr. Bosworth provided services to Farahead? Because as I understood it, they provided services to the three Arcadia subsidiaries.
They do not provide services to Farahead.
So they do not have an employment relationship for EU purposes with Farahead. Now, it may be, as you showed us earlier, when you were applying Article 5, you can apply it also to the parent on the basis that you can't evade jurisdiction if there's an employment relationship with the subsidiary. That's a different point. The employment relationship is with the subsidiaries. I think you accept that.
No, my lord, I don't accept that. Because the contract of, my lord, the putative employer does not need to have any employment contract with the individual.
But it has to have an employment relationship, doesn't it?
For the purpose of Section 5, the putative employer does not need to have a contract of employment with the relevant company. That's the whole point about group companies. So you could have an employment contract with Arcadia.
I understand, Mr. Eschweger, that the employment contract, insofar as there was one ever entered into at all, was for tax reasons, put in the Singapore company. And the agreed statement before the Supreme Court was that it was Mr. Bosworth and Mr. Hurley who decided that. And you say, actually, no, we didn't mean to agree that. But that's not the point. The point is they did not provide services to Farahead. They were not, on my reading of the authorities, in an employment relationship with Farahead.
I respectfully disagree with that submission, my lord. In one sense, whether or not they are in an employment relationship with Farahead doesn't actually matter for my purposes for this reason. If Farahead, in reality, is directing the company, and so it stands in the shoes of the subsidiary, it doesn't matter whether or not there's an employment relationship with Farahead. So there are different ways that one can look at the analysis. You can
I'm trying to find out what your case is, what the Supreme Court meant when they said, were the appellants in a relationship of subordination to their employing company or companies? And I read that as being limited to the three Arcadia subsidiaries, but when that was put to you by my Lord the Master of the Rolls, you dissented from that.
I do dissent from it insofar as all the Supreme Court is saying is apply the test in the CJEU judgment. What it isn't.
It's you know, you can rewrite lots of things, Mr. Eschweger, but you can't rewrite the order for reference from the Supreme Court. And I ask you to show me the part in the judgment which suggests that the reference in the Supreme Court reference is to anyone other than Arcadia. And you haven't done that yet, but I have no doubt you're going to in due course. It seems to me important because what was ordered for the commercial court to do was to hear further evidence and submissions on whether the appellants were in a relation of subordination to their employing company or companies in the sense used by the Court of Justice. Now show me how the Court of Justice were using employing company or companies to refer to Farahead. Please.
So I took your lordship to what the Advocate General said at paragraph 109 about group companies.
I want to see what the Court of Justice said.
And then we go, that's precisely why in paragraph 31 of the judgment, which is the same bundle, tab 7, it was 90, I believe, was page number. And if we go back to paragraph 31, the reference is to Arcadia, and that is because the Court of Justice appreciates that.
You're not answering the question.
Lord, I
do understand, Mr. Eschweger, that the reference to Arcadia is to all four companies. We do listen to your submissions and we do understand that is the case. That is not talking about what I asked you about from the Supreme Court's reference to the employment contracts. Now, can you show me where the Court of Justice suggested that the appellants were in an employment relationship with anyone other than Arcadia? And by Arcadia, I mean the Arcadia subsidiaries.
The Court of Justice did not say that because that was what was not before the court. What it did say is in paragraph 27 that the absence of a formal contract does not preclude the existence of an employment relationship. Before the national court, we have contracts of employment in the domestic sense with the Arcadia subsidiaries. We now know from the Court of Justice that's not necessary. It's the employment relationship that matters. We also know from what the Advocate General said that the group company point that was in Petter and Semengo Turner is correct in that you are not trammeled by the distinctions of corporate law. You look at the reality, because otherwise companies belonging to the same group would somehow evade.
Well, I understand your submissions on Petter. Yeah. At the moment, I'm still trying to get to the bottom of what the Court of Justice meant in the reference from the Supreme Court? And I think the answer is to be found in paragraph 7 of the Court of Justice's decision, which is they were directors of Arcadia London, Arcadia Singapore, and Arcadia Switzerland, and were each party to a contract of employment with one of those companies drafted by themselves or at their direction. And if we go back, if you give me the page number for the Supreme Court reference,
Yes.
that's at page, what, 300?
127.
I'm grateful. 127. Which is further on.
And we then see to their employing companies or companies in the sense used by the Court of Justice, see paragraph 7 might have said.
But, my Lord, it doesn't say paragraph 7. What it is saying in the Supreme Court is apply the test in judgment. I accept, of course I accept, that the appellants have contract of employment in the domestic sector with the Arcadia subsidiaries and not with Farahead. But that's not the issue. The issue is, notwithstanding that official position, which doesn't affect their group roles, what is the situation? Where is the subordination in your group role? That's the key point. It's the group role that matters, my Lord, not the position for the individual subsidiaries. Because Bosworth and Hurley are providing their roles on a group-wide basis. So if we go then to the judgment, which is in the core bundle, and we were looking at the judge had recorded the various submissions. And that paragraph 21 is where he actually analyses what Halterman had been saying. And he first says that Halterman doesn't fit my proposition because the CJAU doesn't repeat the words of 47. In my submission, that is not a strong argument at all, because 31 approves 47 of Halterman. And the judge then says this. Paragraph 31 of Bosworth's judgment reads, Bosworth and Hurley had an ability to influence Arcadia that was not negligible. It does not say an ability to influence Farahead, the controller of Arcadia. My lords, we've seen that that is not correct as a matter of language, and nothing that Sir Michael Burton could say gets round the fact that the court of
Mr. Eschwiger, it's exactly correct. It does not say Farahead. It says the Arcadia, which means the Arcadia Group.
My lord, no. If we go back to paragraph 8 of the judgment, where I began this morning, the judgment, Arcadia means all the claimants. That's the point.
I understand that, but when he says, simply reads Bosworth and Hurley had an ability to influence Arcadia that was not negligible, and says it doesn't say Farahead, that is correct. Farahead is 1 of 4. Arcadia is 4.
The judge is drawing a distinction between, if you like, the overall group and the subsidiaries. That's why his approach is to look at the subsidiaries. It is not right for the judge to say that the CJAU was not talking about Farahead in paragraph 31. It was.
No, he doesn't say that. You cannot twist it, Mr. Eschwiger. I'm sorry. He does not say what you just said. He simply says that the passage does not say an ability to influence Farahead. That's what it says.
That is what it says.
And that's correct.
It's not correct, my lord, because in 31 of the judgment, Arcadia includes, that reference to Arcadia includes Farahead.
Well, the judge says that at the end of paragraph 21.
He records my submission, I correct, my lord, but he doesn't then actually deal with it. And that's the problem.
Well, he deals with it over the page. 24.
24. Yes,
That they were not considering any question of control over or influence.
So at 24, he addresses the point, we're not concerned with Farahead, but 24 refers to paragraphs 32 and 33, and all those paragraphs were concerned with were the shareholder's ability to hire or fire. It's
And
not
give
about,
general directives.
and give general directives, as my Lord Justice Henderson said. And we, in one sense, those words are not particularly informative. What 24 is saying, what 24 is saying, well, look at what 32 and 33 will say. Farahead is irrelevant. That's not correct. 32 and 33 are only about power to hire and fire. That's the only point that has been made in 32 and 33. It is not the case that you ignore Farahead. That's precisely why 31 says Arcadia, not the Arcadia Group, because you're looking at it as a whole, not simply at the subsidiary level. And in my submission, this is where the judge goes wrong, because first, he just ignores the language of 31, he ignores Farahead. And then, secondly, what he then says, his approach, as you see at paragraph 31 or 36, is to look at the power over the company, i.e. the subsidiary companies. So as it were, downstream. And that, in my submission, is where the judge has gone wrong, because he is assuming that you just ignore the group level and you go straight to power over the subsidiary companies. And I've always accepted that Bosworth and Hurley, as CEO and CFO, have all the usual powers of a CEO and CFO. So of course they have power over the Arcadia companies. That is not in dispute. The question is whether that was what the CJEU said the approach was in the test. We've covered this already. Paragraph 24 is when the judge tries to, is the judge's reason why he's not concerned with Farahead. But as a result of the judge closing his eyes to, if you like, the Farahead role at that group level, he simply looks at matters downstream. And my lords,
Mr. Treasurer, I have great difficulty in understanding the consequences of your argument. That it's clearly possible to have an owner in the position of Farahead who does nothing other than sit in Norway or Cyprus and receive dividends and never takes any part in the running of the company at all. If that had been the case, you could not possibly say that the lack of control of Bosworth and Hurley over Farahead meant they were in a position of subordination.
I agree with that entirely.
Yes, so your case has to be that in fact, not as a matter of structure, but in fact, Mr. Fredriksen, through Farahead and his colleagues, gave sufficient instructions to Messrs. Bosworth and Hurley to count as them being in a position of subordination. That's your case.
My case is that Farahead has the instruction-giving role.
No, not a role, not an ability to give instructions, but in fact, as a matter of fact, gave instructions.
That is
controlling, do this, do that. That's your case.
That is my case, my lord, yes. And I'm going to...
But that's the case that Sir Michael Burton investigated. His whole approach was to ask, who was it who determined how Messrs. Bosworth and Hurley did their job? Was it Mr. Fredriksen through Farahead who was telling them to do this, do that? Or was it they themselves who had sufficient autonomy to run their own affairs? That's the question he asked.
My lord, what he did, and you see this in paragraph 36, is he doesn't ask the question that your lordship posed to me. What he talks about in 36 is whether the claimants have power over the Arcadia companies, such that they have non-negligible influence over those companies. That was what the judge investigated. So he's looking at that question. He's ignored the prior question, which is, what is the decision-making body for the group? That's where he goes wrong.
But I don't see why there is a prior question. You've accepted that the mere fact that an owner has the ability to tell directors what to do isn't enough. The question is whether the owners did tell the directors what to do. And he's decided on the evidence, which he had a huge amount of, that the better of the argument is that the directors themselves had a non-negligible influence over what they were doing. Why is that not enough? What separate question is there?
There are 2 points. The first is you've got to identify who gives the instructions.
But that's what he's doing. He's looking at, is it Mr. Fredriksen telling them what to do, or is it they deciding what to do? That is what his paragraph 36 is directed at.
His paragraph 36 is directed at CEO and CFO have power over the company. The evidence is that Bosworth and Hurley had considerable autonomy. That's my learned friend's evidence. The issue is, and I accept, in terms of day-to-day managerial activity, Bosworth and Hurley carry out the performance of their duties as CEO and CFO. But that
do you accept that that means they have, in the judge's words, a more than negligible ability to influence the Arcadia companies?
I do accept that, yes. The companies, yes, I do accept that. The subsidiaries, yes.
Well, why does that not mean they're not in a position of subordination to the subsidiaries?
Because we are looking at their role is the group role. And so you have to look at the group. You can't simply look at the subsidiaries. The CEO and CFO of the group carry out group roles. So the higher role. Yeah.
If you define the group, which you did right at the beginning of your submissions, including Farahead, they are not CEO, CFO of the group as so defined, because they had no role in relation to Farahead. What you mean is they were CEO, CFO, 3 Arcadia subsidiaries, who were put in that position or allowed to stay in that position by Farahead. And the question was, who ran those subsidiaries? Was it them or was it Mr. Fredriksen? And the judge has said, and you've accepted, they had a more than negligible ability to run the companies themselves. So I go back to the question I asked, are they in a position of subordination to those 3 companies? And at the moment, I'm struggling to see either judge asked the wrong question or came to the wrong answer.
They are in a relationship of subordination to the company when you understand how the subsidiary companies make decisions. So this goes back to the point I spoke about earlier, i.e. Farahead either stands in the shoes of the subsidiaries or the subsidiaries delegate their powers to Farahead, or Farahead, as the group parent, is the putative employer. The reason why it's not sufficient to say, well, they are subordinate to the subsidiary, there's no subordination with the subsidiary, is because Bosworth and Hurley are performing a task above the subsidiary at the group level. So that's why the hierarchy, the relevant hierarchy, is between CEO and CFO, and is there anyone above them in that hierarchy? Not at the subsidiary level. Because if it's merely at the subsidiary level, you ignore the group context. The contracts of employment, for what they are worth, do not give Bosworth and Hurley any group roles.
The contracts of employment are not worth anything, because we're not interested in the domestic law.
No.
We're interested in the European employment relationship. I still have great difficulty in seeing that there was even an arguable employment relationship with Farahead, which seems to me that what the Supreme Court remitted to the commercial court was whether they were in a subordinate relationship to the 3 subsidiaries, which were the employing company or companies and that on the findings by the judge, he was satisfied that the claimants had got over the hurdle, showing that they had more than a good argument, or had a good arguable case to that effect. That does seem to be a very simple analysis, and whereas yours seems a very complicated analysis, and I don't see how it starts, I'm afraid.
The analysis is not complicated once one appreciates we're looking at the group. That's why 31 refers to Arcadia. And so when we've seen Holtman, we've seen what the non-negligible test means. We then go to 31, we see the reference to Arcadia, and the question for the court is, in that group context, is there a relationship of subordination? And the reason why you've got to take the group context into account is because otherwise, if you're simply looking at the subsidiary level, you ignore A, what CJEU says, and B, you ignore the reality about how the appellants carried out their group roles. They're performing at the group level, not the subsidiary level.
Well, Mr. Shepard,
Yes.
Eschweg, I think we've got those submissions. I think we better move on.
Of course, yes, my lord. So I've made the point about language, the language of 31, which the judge ignored. We've talked about the group context that the judge ignores, and just briefly, so we can see how this group operates, we can go to the Arcadia Group, or the Farahead Group structure, and that's also in the supplemental bundle. It's in the second volume. It's tab 33, beginning of 289, I'm told. And if we go to the structure chart, just so we can see immediately how this group is structured, which is page 282, it's page 282 in the bundle, 292, I'm told, in the PDF, and 293. And this is a structure chart, management chart. And you see at the top is Farahead, then organisation, line of command, then board of directors. The board of directors is Farahead. So the board of directors is at the top. Then you see below BOD, the board. You see PB below BOD, that's Mr. Bosworth. And you see across the page function and business units. So this group is structured in a way that many groups are structured. It's structured by function, going up towards the relevant board of directors being Farahead. And you see immediately Mr. Bosworth is below board. So that's why it's important to look at the group structure in reality. I very much endorse what my Lord Justice Henderson said earlier about general directors. You're looking at what in reality is going on here. And the functional approach to groups is exactly what the Supreme Court said in Oparbing was how groups could be structured. And in that context, if you have a vertical structure, you disregard the subsidiary's own legal identity. And you see that here. It doesn't matter what the subsidiaries are doing. What matters is the function, the business units that funnel up to the board. And that's why you've got to ask, do Bosworth and Hurley get their instructions from, if you like, what I call the board? It doesn't actually really matter how the label you use. It's also because we have this group structure that Farahead has consolidated accounts of the group. Farahead is set up specifically to hold the Arcadia Group subsidiaries. It has no other function. Its role is to be the parent of the group. And you see immediately from this structure, it's at the top. It's the top of the line of command. And it's also why we have this group structure that explains why Bosworth and Hurley had the ability had non-legible influence over the companies. Because what's happened here, and it's my learned friend's evidence, is that the boards of the subsidiaries were neutered at Farahead's direction. We can go to the evidence on that. It's Mr. Hannes's evidence. Also, well, it's in the first supplemental bundle, tab 25, which is page 227 in the PDF. I beg your pardon, tab 29, which is 270. This is Mr. Hannes. Mr. Hannes is a director of Farahead. He's also a director of some of the subsidiaries. And if you turn to paragraph 25, Mr. Hannes's evidence is this. Farahead trusted Bosworth and Hurley to manage the Arcadia companies appropriately. It was not necessary to have boards of directors that actively supervised them because the Arcadia Group reported its profit and loss to Farahead regularly. So Farahead says we don't need to have the boards supervising Bosworth and Hurley because all the functions go up to us, Farahead. And you see that also in the evidence of Mr. Adams. Mr. Adams is now the CEO of Arcadia. And if you turn to tab 28, which is the tab before and the page number is 262, and you go to paragraph 31, which is 257 in the bundle, 266 in the PDF. This is what Mr. Adams says. He's talking about reporting to the boards, and he says in the second line of that paragraph, the boards of the Arcadia companies performed the functions that the shareholder, i.e. Fredriksen, intended them to, i.e. they performed all the necessary corporate administrative functions. However, the strategic direction and so forth resides in the hands of the group CEO and the group CFO. So what is happening here in this group is we've seen from the structure chart a vertical structure divided by function. You report to the board at the top, and the subsidiaries they have no real remit because it's not necessary for them to have any remit. Farahead has decided that the reporting and the supervision is to be to Farahead. So we've looked at language and we've looked at group context. The third reason why the judge was wrong is that he fails to distinguish between existence of subordination and degrees of subordination within a relationship. And that's because any CEO or CFO who exercises their usual authority necessarily has a considerable degree of autonomy over the performance of their daily tasks. That's a function of their seniority. But that does not mean that they are not subordinate. A light touch does not mean that there's no subordination. And take the example of an army. The general doesn't supervise the colonel's duties on a day-to-day basis. But the colonel is still subordinate to the general. And I quoted in my skeleton the analysis of Mr. Justice Andrew Baker in the Cunico case, who was addressing this very point. And yes, that case is before the CJEU judgment, but it's an illuminating analysis in the context of Section 5. And it makes the point that the fact you've got a CEO or a CFO does not mean there's no employment relationship. If something goes wrong, that does not mean that the putative employer, because he hasn't supervised the putative employee, can get round Section 5. We've looked at 21 of the judgment. We've looked at 24 of the judgment. I want now to look in the judge's reasoning at 25, where the judge says, well, on my analysis, there'd be no reason to look at all the factors and circumstances. The matter can be decided simply on the basis, which is common ground, the defendants had no ability to influence or control Farahead. And then he says this, I'm satisfied that the issue which the CJEU resolved, though on the basis of assumed facts, is that the defendants had a non-negligible influence on the group company. We know that's, on my submission, that's not right. That is not what 31 is saying. What the judge's point here is, this whole debate can be resolved simply on the basis that Farahead, there's no ability of Bosworth and Hurley to influence Farahead. Now, my lords, there's nothing odd about the fact about resolving the case on that basis. We've seen the group board, and we've seen that Bosworth reports to the group board. The reference to all the factors and circumstances needs, of course, to be read in the context of a jurisdiction. So it's not possible for the court to look at all the factors and circumstances. What it does is to look at the relevant factors and circumstances once you know what the test is. As I said earlier, in my case, the test is the approach, is the Holton approach, which is first identify the decision-making body and ask, is there non-negligible influence on that body? And I will explain when we move to ground 2. What my learned friends want to do is say, well, this is a factually intensive inquiry, and that's inconsistent with the mechanistic nature of the jurisdiction challenge. The fifth reason why the judge was wrong was he ignores the other CJEU case law. And that case broadly says that the mere fact that you have wide discretion in the performance of your duties, latitude in the performance of those duties, not even being actively supervised, does not mean that you are not an employee. And what the judge says is, I don't need to worry about any of that, because all the CJEU was concerned about was Holton. In my submission, that's not correct. You will recall that paragraph 25 of the CJEU judgment referred expressly to the case of Kiski. That concerns employment law context. It concerns the worker. It concerns the very directive that is also at issue in Denosa. And Denosa was a case where you've got a sole director who establishes, gives her own remit, her own tasks, has a margin of discretion in her performance of her duties, and the court still says she still is an employee within the meaning of European law. What the judge doesn't do, the problem with the judge's test, is if you're simply saying, look at the power over the companies, then you remove, in my submission, any degree of discretion or autonomy from the individual. Because any senior manager has autonomy in the performance of his day-to-day duties. The sixth reason why the judge is wrong, and this goes to paragraph 23, is given, the judge said, well, given the disagreement as to what 31 means, I'm left with what seems to me to be important. And then he refers to the reference at 29 and 30. Problem with that approach is that the reference, as we know, was factually incomplete. That's precisely why the Supreme Court remitted the issue to the judge, and the judge records that point for what it's worth at paragraph 4. The Supreme Court was persuaded by the defendants. The facts underlying the conclusion by the CJEU as to the relationship of subordination had not been considered or found by me, and the Supreme Court ruled as follows. So it wasn't good enough, it's not sufficient for the judge simply to rely on what the CJEU said from the reference is important, because the whole point of the remission is that the full facts were not before the CJEU. We did not know that Farahead was the group board. So when you put all those errors of approach together, when the judge comes to 26 to look at the evidence, he approaches the issue from the wrong starting point. He looks only at control downstream on the subsidiary companies, and in my submission, any CEO, any CFO would necessarily be outside Section 5 on that approach, and he doesn't undertake the relevant inquiry, which is first, what is the group board? He asks the wrong question, and therefore he cannot give the correct answer. Now, my lords, I see the time. I have finished ground 1 and my analysis of Burton judgment. I do have ground 2, but that's much briefer. And at that point, I would have completed my submissions on the law, and there will then be time for me, if the court so desires, for me to go on to explain what would the consequences be if the judge got it wrong in the law.
I think you will need to go on and explain what you say the consequences would be. We'll resume at 2 o'clock.
I'm grateful.